Well, hello and good afternoon. I'd like to welcome you to today's Lunch and Learn online masterclass webinar, Law in Australia with Dr. Amelia Simpson. So this webinar is brought to you by the ANU College of Business and Economics and the ANU College of Law to promote our new joint program, the Dual Masters program, the Master of Financial Management and Law. I will now introduce you to our presenter for today, Associate Professor Amelia Simpson. So Amelia Simpson is an Associate Professor at the ANU College of Law at the ANU, where she convenes law and legal institutions that is taught to students in our Master of Financial Management and Law program. And Dr. Simpson is one of Australia's leading scholars of discrimination and equality principles in constitutional law. Her research on the interstate free trades doctrine has been cited and quoted in Australia's High Court and Federal Court, and she's also won multiple awards for her teaching at ANU. So we're very excited today to welcome Amelia to present her masterclass on law in Australia. Thank you, Amelia.
Thanks, Rosa. Welcome everyone to this ANU masterclass. My name is indeed Amelia, and I'd like to begin our class by saying that I acknowledge and celebrate the first Australians on whose traditional lands I stand today, the Ngambri and Ngunnawal people of the ACT region, and I pay my respect to their elders past and present. I've been teaching law at ANU for 20 years, and throughout that time, some of my very favourite teaching has been to new postgraduate students who bring a wealth of experience of their own and are full of very good questions. Teaching and researching law in Canberra is a particular privilege, and the ANU's proximity to the organs of lawmaking, the Federal Parliament, the government departments and the High Court, gives my ANU colleagues and me a unique degree of access to those organs and people who power them. We're often called on to advise on those questions and to advise those people, and we learn from them and we get a lot of great gossip. Because today's class is intended as an introductory taster, I'm going to lead you through 3 small modules, and 4 if I have time, to give a flavour of what you could expect to be learning as an incoming law student at ANU, a postgrad law student at ANU. Law is one of those disciplines in which it's not really possible to specialise until you have a basic grounding. So while I know that you're especially interested in the law of financial management, if you do decide to come to ANU and undertake our new Master of Financial Management and Law, you'll be doing Law 101 before the specialisation happens. And today's topics are all part of that Law 101 landscape. So let's get stuck into our first mini module. Each of these will take about 10 minutes or so, and depending on how many questions I get from you, we'll either stop after the third and pass back to Rosa and her colleague Tom for some more information about the program, or I might be able to squeeze that 4th one in. We'll see how we go. I'll pause to respond to any questions that you have popped in the Q&A box as we go. See, there's a button at the bottom of your Zoom window called Q&A. You can submit a question there anytime, and once I've got a couple of them pop up, I'll pause and answer those. The first of our mini modules today, we've just called an introduction to law. In trying to define law, we usually, in the discipline of law, come at it from a kind of purposive viewpoint, and we say that the purpose of law is what it's all about. And the purpose of law, we say, is twofold. First of all, it's to regulate human behaviour, to provide a framework in which we can relate to one another in employment, in marriage, in commercial dealings, in protection from dangers, and many, many other things. The second purpose of law is said to be to provide a means of resolving our disputes. There's a lot of cross-cutting sources of law in the modern world, and each country has its own unique combination of these configured in its own special way. Modern Australian law can trace some of its roots to Christian traditions, to moral and political philosophy, to the ancient Roman codes, to international norms, and in recent times to the legal systems of Australia's First Nations peoples. But the most prominent source of Australian law is, of course, the British common law heritage that was transplanted here in 1788 when the newcomers claimed this land for the British Crown. That heritage spawned two major law-giving institutions of contemporary Australia, the legislatures and the courts. We have 9 legislatures in Australia today. There are 6 state parliaments. There's 1 national parliament here in Canberra, and there are 2 territory legislative assemblies. All of them are churning out legislation, and much of that legislation in turn appoints delegates to make additional subsidiary rules that we call delegated legislation. So that covers things that you may know by the name of regulations, bylaws, orders and rules. We'll have a look more closely at legislation as a source of law in our 3rd little module today on structures of government. The other side of the lawmaking coin is our courts. In Australia, there are 9 distinct court systems, 1 for each state and territory, plus a federal system. With each of these court systems relating to one another in a hierarchy. All 9 of these court hierarchies have the High Court at the very top, though, and this allows the High Court to perform an important function of standardising the principles as much as it can across the nation. We'll return to this when we look later on at something that we call precedent in our court system. One further source of law that continues to grow in importance is international law. There are 2 main types of international law. The first is treaty law, and the second we often call customary law. Treaty law is the international law that is made by nation states negotiating agreed terms, a bit like a contract. Customary law arises more organically through the agreed norms of behaviour of nation states, as evidenced in their actions. Other sources of international law are the deliberative bodies, so that includes the UN General Assembly and Security Council, and also the international judicial bodies. That's the International Court of Justice, the International Criminal Court, and from time to time some ad hoc tribunals such as we've had recently in Rwanda and the former Yugoslavia. But crucially for us, international law is not directly enforceable in Australian courts. To be enforced, it must first be incorporated by local legislation. So that is explicitly included in an Australian Act of Parliament, often as a schedule or appendix. And the World Heritage Protection Act, and the Racial Discrimination Act, and numerous other big high-profile national pieces of legislation have big slabs of international law included at the end in that way. I'll put sources of law to one side for the moment and say a little bit about the ways in which we classify law in Australia. There are a whole lot of binary distinctions that we draw to help slice and dice the content of our law. And as we were just referencing international law a minute ago, I'll begin there. International law we can and do contrast with what we call municipal or domestic law. That distinction is pretty intuitive, though many people haven't, before they come to study law, heard the terminology of municipal to describe a country's own national law. To break international law down further, we can contrast private international law with public international law. Private international law is the law that applies international standards to private citizens in their dealings across national borders. So corporations and other non-government actors, people, individuals. While public international law is the law applying to nation states, governing the conduct of governments. Turning to Australian domestic law now, we can distinguish between public law and private law. Public law is the body of rules about the origins and use of public power, the power claimed by governments, parliaments and courts. While private law is the rules that apply between two private citizens or corporations or other non-state actors. So that includes things like contract law, property law, defamation law, negligence, anything that involves parties who are not representing the state or government. Another important distinction within Australian law is the one that we draw between criminal law and so-called civil law. Criminal law covers all those things designated as crimes, actions that we regard as offensive to the whole of society and punishable as such. While civil law is everything that is not criminal law, and it can include things that are offensive to some people, so acts of defamation or trespass, for instance, but not the whole of society, as we say in the case of criminal law. When we talk about the sources of our law in Australia, we often distinguish between statute law and what we call common law. When we use the term common law here, what we mean is the rules that are made by judges in courts. While statutes, of course, means the law created by legislatures, those parliaments and assemblies. Statute law is another term for legislation. We use those two words interchangeably in Australia. Perhaps confusingly, though, the term common law has other meanings as well. You sometimes hear people drawing a distinction between a common law legal system and an alternative called a civil law system. When used in that way, common law means the court systems in the common law world, the former British Empire for the most part, with its adversarial proceedings. An adversarial is a term I hope to explore later on in today's masterclass. In contrast to that, civil law means the court system of continental Europe and many other places worldwide now, with a different inquisitorial process being followed in court hearings. That, I think, is enough material in this little mini module. Let me see if I have any Q&A. Okay. Okay, there's a question that relates to the program. I will defer that question until later because I think Rosa and Tom are better placed to answer that one for you. And Elaine, who's also helping us out today. Okay, someone's asked, what does the abbreviation CF mean? That means compared with. That's just a shorthand that's popular in law writings for in comparison with. That's a very good question to have asked. Thank you to the person who asked that. Anyone else want to chime in with a question about what we've covered thus far before I change the subject? Nope. Okay. All right. Well, look, let's move on then. We've got plenty of other things that I hope we can get through before our time's up today. So I'll turn now to talk about the basics of precedent. This little module is intended as a taster on case law and the system of precedent that holds it all together. The centuries-old principle or doctrine of precedent is the centerpiece of our common law legal system. In essence, the doctrine of precedent means that judges today must decide cases on the basis of legal rules determined in earlier cases with similar facts and issues. At this point, new law students often scratch their heads and say, really? Is there always a past case that is like whatever case is before a judge in the present? And the answer is usually there's one that's close enough to be useful, even if it's not super close to the issues before the judge in the moment. It is very unlikely that any previous case would be exactly the same in every respect as the case before a judge on a given day, but that's not what judges are looking for when they set off to find the right precedent. They're looking for core similarities in what we call the material facts, the facts that intertwine with relevant legal principles. So the fact that a particular crime took place on a Tuesday does not mean that the legal principles established in the resulting judicial decision can only be applied in future cases where the events took place on a Tuesday. The day of the week is unlikely to be a material fact that was closely tied to the principle of law that was laid down by the judge in the earlier case. The same goes for, shoe size, eye color, probably not material facts, but whether an accused in a previous case was intoxicated or could not read English language signs or was provoked by the victim, they're all much more likely to be material facts of a kind that can make one case sufficiently like another case for precedent to connect the two. When one case is relevantly like another, and whether or not one case is relevantly like another, lawyers strenuously argue about this in court proceedings and in preliminary documents that they exchange. All the time, we see cases that essentially are a debate about whether or not the new circumstances are on all fours with, sufficiently similar to, circumstances that happened in an earlier case, such that the outcome is predetermined by that earlier outcome, applying the doctrine of precedent. It's one of the main bases on which court cases are won or lost. There are many more layers of nuance in working out what is a relevant precedent and what is the precedent that a particular case sets. I'll just mention a few of the key principles that keep the whole system in check. First of all, each court and its judges are bound by decisions of courts higher up in the same court hierarchy. And by bound, we just mean must follow those decisions coming from above. Here's a simple diagram of a court hierarchy. This one is Victoria's, where a case enters the hierarchy depends on the amount of money at stake or the seriousness of the charge in a criminal context. And then if there's an upward appeal, the case moves to the next level in the hierarchy. And it has to stay within that hierarchy. It can't move sideways into a different hierarchy. Another key principle that underlies our system of precedent is that a decision coming from a court in a different hierarchy or from a court lower in the same hierarchy can be persuasive, we say, but it's not binding. So, in other words, a court looking at such a non-binding earlier decision can choose to follow it if it's not bound by some other contrary precedent. So if it seems compelling, it can be relied upon, but it can also just be ignored if it seems unsuitable or unfair or otherwise an unattractive direction for the law to go. Next principle, only the ratio decidendi of a past case is binding. Ratio decidendi is one of the legal Latin terms that is still widely used in our Australian legal system. And it means reason for the decision, the core reason that explains a particular decision that a court has made. So only that part, only the core piece of reasoning is transferable down the line to subsequent courts when they are considering similar sorts of facts. The fourth principle relates to a different part of a past case, the obiter dicta, which means a passing remark. These bits, the bits we designate as obiter dicta, are not binding on future courts, but they can be persuasive, just like a case from a different hierarchy can be persuasive. The fifth principle is that case law may be overridden by legislation. One of the most important principles in Australia's legal system is an idea that we call parliamentary supremacy. And essentially that means that parliaments have the most potent form of power in our system, and they can override the decisions of the other branches of government, the executive and the judiciary. And so whenever a parliament doesn't like any of the rules that courts in its jurisdiction are making, it can create a statute to just wipe those principles out. The technical term for that is abrogation. We say that a court abrogates a legislature abrogates a case law principle that it doesn't like. There's one small proviso to that in Australia, and that is that parliaments cannot, in Australia, abrogate case law that involves an announcement of the meaning of the Constitution. The High Court is the interpreter of Australia's Constitution, and insofar as a particular case is a statement about what the Constitution means, Parliament can't pass a statute to dislodge that interpretation if it doesn't like it. The sixth and last principle that I'll mention is this: precedents do not lose their force just by the passage of time alone. You don't judge the value of a precedent by how long ago it was decided. A decision that is 100 years old or hundreds of years old can sometimes be the source of a legal principle that a court applies to decide a modern dispute. You don't see it every day, but you certainly do see it fairly often in Australian courts. One of the really interesting things about case law is the way in which its legal principles develop incrementally. The ratio decidendi of a case, which we often just call the ratio for short, can be a bit like a seed that grows into a plant that is then pruned and grafted by a range of other people and can end up looking quite different from the vision of the person who first planted the seed. So long after a case is decided, all the various subsequent developments can end up influencing how we view the original decision and what we say it stands for. We can see this in the story of the famous tort case, Donoghue and Stevenson, where the British House of Lords found Mr. Stevenson, a ginger beer manufacturer, liable for the food poisoning suffered by Mrs. Donoghue, who had drunk a bottle of his ginger beer that had a decomposing snail hiding inside. Donoghue and Stevenson is the case we now think of as having invented the principle of negligence within tort law. Prior to this case, if you didn't have a contractual relationship with someone, then the harm they caused you by, for instance, making a defective product was not actionable. You couldn't bring a court action and get any compensation from them. The difficulty for Mrs. Donoghue in trying to get compensation for her illness was that she was not the person who'd purchased the ginger beer. Her friend had. So her friend had a contractual relationship with Mr. Stevenson in which he was taken to have warranted that his product was fit for consumption, but Mrs. Donoghue didn't have that relationship. We say that the ratio decidendi, the core principle from Donoghue and Stevenson, is this passage on this PowerPoint slide behind my head. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected. So we knew straight away, as soon as this case was decided, that this principle meant that people who drink contaminated drinks made by a not very careful brewer were liable to the application of this rule, this legal rule. But within 4 years of the decision in Donohue and Stevenson, this neighbour principle, as it's now known, had been applied in Australia to a clothing manufacturer who'd produced long johns with wool that had been contaminated with some sort of irritating and burning chemical. So the notion of what could be negligence grew a little. And within 30 years of the original Donohue and Stevenson decision, the neighbour principle had been applied to the architect of a shire hall that collapsed on top of some unlucky meeting goers. The High Court accepted the argument that an architect could be considered to be just like a manufacturer. And the scope of negligence as a concept was pushed outwards a little more. And so that's how case law develops in small steps, case by case, over many years, with generation after generation of judges adding a bit, sometimes pruning a bit off. So the principles are in a constant state of evolution. Now I'll say a bit more about the other Latin phrase that I used a few minutes ago, obiter dicta. Remember, this is a little piece of legal Latin that means a passing remark. But in law, the concept of obiter dicta means more than that. It means things that judges say in deciding a case that aren't strictly relevant to the case in front of them, but might be useful in the future to resolve other cases with different facts. Crucially, obiter dicta are not binding on future courts, but they may be persuasive, which is in part a function of where the obiter dicta comes from. From the High Court, it's always persuasive, but judges are less interested in obiter dicta passing remarks coming from judges lower down the court hierarchy. And there's one last thing I wanted you to know about decoding judicial reasoning in cases. Not everything a judge says in a case can be classified as either obiter dicta or ratio decidendi. There's lots of other stuff that they say as well. There's usually a description of the facts. Often there'll be a discussion of some of the cases that the parties have held up as relevant. There's sometimes a survey of academic literature on broad questions that the case raises. And my point in saying that is just that you don't have to label everything as either ratio or obiter when you're reading a case. If you would like to have a go at finding some judges' reasons and seeing how you go at understanding them and seeing if you can figure out what the key principles are that might become ratio and be passed on as precedent, check out this website. This is a free Australian university-sponsored web page in which all of the decisions of almost all Australian courts are recorded. So you can browse around, you can find a case and challenge yourself to find out what the case's key principles are and what that might mean for other fact scenarios in the future. That's probably all I've got to say on that point. Let me have another look in the Q&A. Okay, Elaine is answering that question. So thanks, Elaine. I'll leave you to it. Looks like there's nothing else about that material. All right, look, I'll race on with one more. I think I've got time to cover one more of my little mini modules. And this is about legislation. What I want to do in the next 10 minutes is just explore legislation as a source of law and talk a little bit about how its meaning is interpreted and determined. I've mentioned already that we have 9 legislatures in Australia at the moment. The oldest and most powerful of these are the 7 parliaments, one for each of the 6 states, and a 7th, the most powerful of all, being the Australian National Parliament. And if you are very well travelled around Australia, you may be able to name some or all of these 4 randomly chosen Australian parliaments behind me. All of Australia's parliaments, plus the 2 territory legislative assemblies, which are more recent creatures, are making legislation that applies as law in the geographic area that matches the relevant legislature. They all have a geographic area, and their laws only really apply to people and activities within that geographic area or having a link to that geographic area. There's been a vast increase in the volume of legislation in Australia over the past century, and the pace of its creation just keeps on quickening. There are lots of reasons for this, but the most important probably relate to the increasing complexity of the world, including the pace of technological change and the rise of global commerce. There are quite a few suggested advantages of making new rules in the form of legislation rather than as judge-made case law. And I'll just mention a couple of these. It's widely understood and appreciated that legislation can be proactive in addressing a perceived problem. Legislators can see a problem and resolve immediately to do something about it, unlike judges who must wait for a suitable dispute to be brought before them before they have the opportunity to change the law. Fans of legislation also talk about its capacity to execute legal U-turns in the sense of a dramatic major law reform, and to do so with unquestionable democratic legitimacy. Some of the best known examples of this legal U-turn concept in Australia are no-fault divorce, the recognition of Indigenous native title, laws to tackle race and sex discrimination, and no-fault motor accident compensation schemes. A third advantage is that statute law, unlike case law, can set out to regulate a vast area and to do so in a lot of detail. Modern governments need to be able to do this, given the complexity of our world. In Australia, as in most developed liberal democracies, we have some very long pieces of legislation. Some of the longest are the Income Tax Assessment Act, the Corporations Law, and the Social Security Act. I'm in the way there. There we go. Just check out the sizes of those pieces of legislation. They're enormous, which means that for lawyers, you kind of got to specialise in just one of those topics. It's very hard for one lawyer alone to be able to competently advise clients on all 3 of those things. Most people who advise on one of those things advise on just that one thing, because there's just so much detail to be across. Yet another suggested benefit of legislation is that it can, in theory, change more easily and decisively than case law can. All legislatures in Australia are able to amend or repeal existing legislation by following the very same steps that we follow when we create it, or when they create it. So it's actually creating a new piece of legislation, the purpose of which is to alter or undo an existing one. There's the second tier or layer of legislation that's often overlooked in Australia that I mentioned at the outset, but it's very important, and that's delegated legislation, sometimes called subordinate legislation. Those 2 terms are interchangeable, delegated and subordinate. And they refer to the laws that are made by a delegate of Parliament, either a person or a body, under the overarching authority of a piece of primary legislation, an act that's made directly by Parliament. There are several subspecies of delegated legislation, which differ slightly in form and also as to the identity of their makers. Some of the most common that you see in Australia are made by governors general or ministers, and they're typically called regulations. We also have rules, which are often the product of courts acting as delegates. We have bylaws that are made by local councils acting as the delegates of state parliaments. The rules for how delegated legislation must be made and by whom are spelled out in the primary legislation that does the delegating of power. We often call that the enabling act. So here's an example taken from a piece of legislation that is dear to my heart. That's the section in the Help Act that confers the delegation on the Governor-General to make delegated legislation. So it often takes a form a bit like that. It needs to be set out in the Act anyway before anyone can be a delegate. And traditionally what delegated legislation has been for has been to flesh out the low level and voluminous detail of a regulatory scheme. Doing that in the form of delegated legislation generally makes it easier to change all of that fine print as the need arises. In the last couple of minutes I've got, I'll just say a couple of things about how we interpret legislation. There's a lot of reasons why it can be difficult to work out the meaning of a statute. Language is inherently imprecise to start with, and statutory language in particular is often complex and technical. Legislators don't have superpowers either. They can't possibly predict every scenario that a new statute is going to need to cover. So when we as lawyers, or you as prospective law students, or anybody, public servants or administrators of any rules, when we pick up a statute and try to interpret it, we're really wasting our time unless we set out to do it in the way that a court would, because courts are the authoritative interpreters of legislation. So it doesn't matter what I think language means. What I need to try to figure out is what a court is going to think language means. So interpreting statutes is an exercise in prediction. There are a bunch of rules that judges follow that they have followed for centuries to help them to navigate difficult questions of ambiguity in statutory language. There's a whole lot of different things they look at. Here are some of the oldest ones. I'll kind of see if I can move my head out of the way a little bit there and just talk to this. So these maxims and presumptions are some of the rules of thumb that judges have worked up over many centuries. They're just rules of thumb though. So if Parliament does really want to, for instance, give a statute retrospective operation, it can do so. It just has to be explicit and say that's what we're doing. So there is no ambiguity. There's only room for these presumptions and maxims to work where there is an ambiguity. Sometimes judges look at extrinsic materials, the debates in Hansard, the second reading speeches that ministers have given when they have sponsored a new bill, and work with those to try to get to the bottom of some ambiguity or other problem with the language of a statute. Anyway, they're just a couple of examples of the sorts of investigatory work that you need to do if you want to predict how courts are going to read legislation. It's really satisfying, I think, and many people think it's like doing a puzzle, and lots of people find that they never tire of that as an activity. Now I'm going to look in my chat box again, and then I probably will hand over to Rosa. What have we got? Okay, so one of our participants today has asked, why is the highest court in Australia the High Court while the courts below are Supreme Courts, whereas in New Zealand, for example, the top court is the Supreme Court with the High Court below? very good question. It may, and I'm not 100% sure, but I have always assumed that it's got something to do with the fact that Australia was several separate colonies which had Supreme Courts before the federation of those colonies into the nation of Australia. So there was already a Supreme Court in Tasmania, Western Australia, South Australia, Queensland, New South Wales, Victoria, and they would have all had to have changed their name if our top national court became the Supreme Court of Australia. So I suspect it was just a pragmatic decision to leave all of those 6 courts with their existing names and create a new name. How they chose High Court, I'm not sure. There is a High Court in the UK, but it's not. It has never been the top of the pecking order. So I'm not sure how the name was chosen. If I had the time to look that up, I'd be interested in the answer. So I might ask up and down the hallway, see if my colleagues know. Any other questions about that before I hand back to Rosa and Tom? There's still time to ask a question if you'd like to. Okay, look, I think now's a good time then for me to finish up and invite you to hang around and listen to the program information that Rosa and Tom are going to share with you now. So thanks very much for joining us today. And you're welcome to reach out to me directly if you've got particular questions about the law material. Thank you.
Right, well, thank you so much, Amelia, for providing such a comprehensive overview of the law in Australia in this masterclass. So I definitely think that I've come away now with a very strong understanding of the legal system in Australia from this short masterclass. So it was very informative and very educational, and I think all of our participants would definitely agree with that. So now I'm going to provide a little bit of information about our new dual masters program, the Master of Financial Management and Law, which is run jointly between the ANU College of Business and Economics and the ANU College of Law. We're really excited to launch this new program. It's probably one of the first of its kind in Australia that does incorporate both a study of the legal system and law in Australia and also financial management. So within this program, you're getting a very strong understanding of the finance world, the business world, and also the system of law and the legal systems. So this degree, the Master of Financial Management and Law, it's highly suited to those working or seeking to work in financial and advisory firms, policy and regulatory bodies, or the legal profession. It would really suit a lot of different public service sectors and also private sectors as well. As I said, it's a jointly taught program, so you would do subjects across both colleges, the College of Law and the College of Business and Economics, and you would learn different disciplinary areas and combining that rigorous ANU courses on essential elements of finance and compulsory and elective law units. So there is some flexibility in that program. And this degree is also available for both law and non-law graduates. So you don't necessarily have to have a background in law to come into this program. So it's very good for those that might have a background in arts, business, science even, and sort of move into that interdisciplinary space in business and law. And the flexible structure is across 2 years. So this is a program that would be studied 2 years full time. You could do that in a part-time capacity, and you could also do that through a flexible study arrangement if you are working full time. Okay, so for the key learning outcomes for this program, the first thing is you would evaluate complex problems, concepts, and theories drawn from the fields of finance and financial management, as well as private and commercial law. And you would devise solutions appropriate to the specific content. So understanding those problems, concepts, and theories is a really important part of this master's program. The second part, because it is a master's program, is undertaking research. So you would do research, writing, and resolution of complex problems within financial and legal and regulatory dimensions across a range of current issues and topics at both a national and international focus. The third aspect is research and writing. So in a master's program, a lot of research, a lot of writing, you'll really hone in on those skills, and you would do that on the theory of both private and commercial law, finance, and the financial sector. Fourth would be to incorporate social and policy related interdisciplinary approaches into the analysis of both financial systems and legal systems. So you would really be honing in on your analysis skills as well in this program. And then fifth is to communicate those theoretical and practical perspectives of legal and financial issues effectively to a range of audiences in both the oral format and also in writing as well. And the sixth thing, which isn't on here, which I like to say is one of the most important aspects of studying a postgraduate degree or a master's degree, is those critical analysis skills that you will learn. Once you leave the ANU with the postgraduate program, you will really have deep critical analysis skills. You will understand why things are the way they are. You'll learn to question things, and you'll learn to analyze, research, and then present solutions to those problems. So definitely one of the best aspects of learning a postgraduate program and finishing a master's degree. Okay, so to enter the program, we do have some specific admission requirements. So you do need to have a bachelor's degree. It doesn't have to specifically be in law or business, and it could be an international equivalent as well. So any of our international guests today, we look at both national and international degrees, and you just need to have a GPA of 5 out of 7. So you could do a quick percentage calculator or have a look if you have a different sliding scale, but the ANU requirement for this program is a grade point average of 5 out of 7. We do have a number of pathways as well, which I'll go through just shortly. And the delivery method is actually varied. So we do have the courses delivered in a range of modes. Some of them are in person, full-time or part-time on campus. And we do have some online and evening and intensive offerings available as well. If you'd like to learn more about that, you can book a one-on-one appointment with myself or my colleague, Brooke, and we can go into more detail on those offerings and go through those courses with you. Okay, so I'll tell you a little bit about the ANU College of Business and Economics. That's where I work as a Deputy Manager for Student Recruitment and Partnerships. We have a very strong international reputation, specifically in the Asia Pacific region as well. We're very well known. CBE grads are well recognised around Canberra, nationally and internationally. We offered a very tailored student experience so that the students that come into our programs are really getting that sort of individual attention. We have small class sizes, and you'll get to know each one of your lecturers and professors that teach in your program. We have world-class academics. So some of our academics that teach at the College of Business and Economics have done amazing things in industry and also have PhDs from some amazing places. I can give you some examples. The Dean of our college has a PhD from Stanford University. We have one of our academics, Bruce Chapman, working in the college. He actually was the architect for the HEX policy that came out. So we have some really inspiring people that you would be learning from within the college. Excellent facilities as well. We have a very lovely building, a lot of study spaces. So you could always, work on your assignments and study for your exams in those spaces. And we do offer a lot of global opportunities as well. So we have our CBE careers team that do seek out different global experiences for our graduates. We also have the perfect balance of academic rigor and practical exposure. So we do have a focus on the practical aspects of getting a job as well. And I'll go into a little bit about our careers team and what they do. So if you study the Master of Financial Management and Law program, you would have access to the ANU College of Business and Economics careers team. So the careers team are a team of about 8 staff that work full-time, essentially sourcing opportunities for our graduates and for our students, employment opportunities. So they're like an in-house recruitment agency for the ANU College of Business and Economics. And their services are available to our students and our alumni for up to 3 years after graduation. So you do have access to the careers team to help you leapfrog into your career of your choice, or to even progress to career of your choice. They offer professional development workshops and career events throughout the year, great for networking, great for meeting potential employers, and they provide assistance with things like career planning, so mapping out a career plan, resume reviews, your interview preparation, your job search strategies and application, using LinkedIn and networking. And then we have our programs as well, which incorporate the CBE internship program and our Momentum mentoring and professional development program. So you do get a lot of extra career services and professional development opportunities by joining the College of Business and Economics through this program. I'll also explain to you a little bit about our short course that we have available, which is a pathway into the Master of Financial Management and Law. Now, there are a number of different pathways. There's a couple available through law as well. And this one is the pathway available through the College of Business and Economics. So the Graduate Certificate of Finance and Actuarial Studies is the pathway program into the Master of Financial Management and Law. It has a duration of 6 months full-time, so it is 4 subjects, and the admission requirement is slightly lower. It's a GPA of 4.5 out of 7. Now, one of the most important things I think while we're promoting the pathways as well is the ANU has currently decided to have a very strong focus on short courses and a discount available for domestic students for this program. So if you're an Australian citizen, permanent resident, or New Zealand citizen, you'd be eligible for this discount. The discount for this program is actually quite significant. It's in the tune of about $10,000. So you would save $10,000 by going in through this pathway program. The indicative fee for this is $7,252 for the entire 4 courses, discounted from a normal $17,280. So this might be a way for you to dip your toe in before going into the program and pathway in. You'd be doing the same courses essentially in the Master of Financial Management and Law. You're just going through it in a different pathway mode. And there's also a law entry pathway mode as well, which Tom will go through. So as I mentioned, the ANU graduate certificates are a new focus for the university. We're trying to push our short courses. We really want to see more domestic students in our programs, and we're offering a significantly reduced rate for the second half of 2021. I do believe this could actually be possibly one of the best value opportunities to study a postgraduate program in the country right now. These reduced fees are for commencing students, and you do need to complete the courses by mid-2022. So that, look at a realistic timeframe, that'd be 2 subjects per semester, semester 2 doing 2 subjects, and then semester 1 next year doing 2 subjects. If you would like to apply for one of the graduate certificate pathway programs or the Master of Financial Management and Law programs for semester 2, we have some key dates for application. You do have to apply by the 30th of June, so we still have a fair bit of time. And you would make that application through the university's admission centre. You can go there through the Programs and Courses website on the ANU. It will take you directly to that application portal so you can apply. So they will close on the 30th of June for most programs. So I will throw over now to Tom for his College of Law presentation, and he'll go through some of those entry pathways through law and give a little bit of information on the ANU College of Law.
Thank you so much, Rosa, and thank you, Amelia, too, for that wonderful masterclass. So I just wanted to share a little bit about the ANU College of Law. We are ranked as a top 20 law school in the world consistently, 17 in the world as of this year's rankings. But what really I think makes studying law, or indeed this master's program, such a unique experience is that at ANU we have what Amelia touched on, this unrivaled access. As this presentation sort of alluded to, it's about studying law where the laws are made. So within very close proximity of where we are here on the ANU campus, you have the High Court of Australia, you have Parliament House, and this access to the expertise that we have, in addition to alumni and our visiting judges program, really gives students a much deeper and personalised legal education. So that's something that we're very proud of. As I mentioned, we're renowned for our experts. So your lecturers, your teachers are recognised as world-leading experts in their field, including Amelia. So in particular, we've got strengths in international law, security law, environmental law, and Amelia's own specialisation, constitutional law. And another really important thing to emphasise when you study at ANU, in particular at ANU College of Law, we're really dedicated to seeing you thrive personally and academically, and that's why we've got really strong support networks in place. As I mentioned, studying law in Canberra, it's so important to contextualize what that means. And so within our international student immersion program, we have excursions to go to some of these national institutions that I've just mentioned, in addition to weekly gatherings. And that's continued throughout the disruption that we've had over the past year with remote learning. We've still been able to stay connected. So that's the most important thing, I think, to really emphasize, especially for international students. It's a big step coming to study in another country. And so just know that we're here to support you throughout that. I'd like to talk a little bit too about our graduate certificates. Rosa, if you're able to just flick through. So as mentioned, we have a couple of graduate certificates here at the ANU College of Law, which offer a pathway into this program that we've been discussing today, the Master of Financial Management and Law. So our two graduate certificates are the Graduate Certificate of Law and the Graduate Certificate of New Technologies Law. These are an excellent option if you are sort of considering postgraduate study, but are a little bit wary about committing to a master's straight away. It gives you a chance to really get a taste of what postgraduate education is like at ANU, and then to be able to receive credit to continue so that you can fast track your master's qualification. So these are both 6 months full time. The New Technologies, Graduate of New Technologies Law, is unique in that you can apply anytime. There's a rolling sort of application for that. And you can actually do that entirely online. So if you are working or have other commitments, that's an excellent option there too. So as mentioned, you can use, you can be recognised for your study there with private and commercial law in respect to the Master of Financial Management and Law, so that you can fast track your study there. And as Rosa mentioned too, there are really significant discounts. I'm so excited by this. More than $10,000 off what our usual tuition fee is. So it's really something that I think is just a fantastic opportunity to take advantage of. So important to emphasize that. And that, I guess, covers us here at ANU College of Law. So I'll hand back to Rosa.
Thank you so much, Tom, and thank you so much again to Amelia for this fantastic masterclass that we've held today. This brings us to the conclusion of our Lunch and Learn masterclass. We will send out an email later just on some program information and also for a feedback survey to see how you enjoyed our session today. But if you did want to contact us for any further information, we do have our contact details up there. I'll also pop in the chat box our one-on-one booking appointments that we do offer. So if you would like to book a one-on-one appointment with a College of Business and Economics digital career advice session that we run, you can do so by booking on the Calendly link that we have there. I'll just pop it up right now. Sorry, I thought I had my cut and paste, but yeah, so calendly.com/ANUCBE, and it'll take you to a booking portal, and you can have a one-on-one session. We can discuss your personal situation and whether or not what program would be the most suitable for you. But yeah, thank you so much to Amelia. Thank you so much to Tom. And thank you so much to all of our participants for coming today. We hope you enjoyed our presentation, and we do hope to see you coming one day to the ANU. Thank you.
Thanks, everyone.